Hello friends, Namaskaram, how are you? Myself is Dr. Jineesh Soni. I am an advocate and a defense counsel. Har Har Mahadev, Jai Shiv Shambhu, Jai Mata Di. With the blessings of Almighty, in today's class, I will explain you how to contest a false check bounce case. So things are simple. It depends upon us in which manner we are going to contest. Because if you are having the assumption that in court we are having justice, you might be wrong. Because you have to sustain the defense. If you are not able to do so, in that scenario, you could not claim an acquittal. So basically, we have to understand the strategy, which is beyond the emotions, because there is no place of emotion in the court of law. We have to proceed legally and logically. So basically, I will discuss one of the most important judgment that is quite recent on subject. Judgment is of Honorable Chhattisgarh High Court, which is dated 10th of April 2026. So basically, we will understand the strategy of defense. So whenever we are going to contest, what points are important and what points are to be kept in our mind. So directly we are moving on the board. Whenever we are going to contest a check bounce case, two principles are to be kept in mind. Number one, the burden is on the complainant to prove the case beyond reasonable doubt. Reference is section 104 of BSA. And number two, the accused is not required to prove his defense beyond reasonable doubt. He is required to set up a defense that might cause probabilizing effect. Simply, it is called a probable defense. So, in the case at hand, that is pronounced by Chhattisgarh High Court, dated 10th of April 2026, prosecution set up a story, which was that the complainant inter alia communicated with the accused to purchase our land, because as per complainant, accused deals in land purchase and sale. Finally, there was an agreement as per complainant of rupees 35 lakhs. The said money is given as advance, and it is decided that sale deed will be executed soon. But there was no sale deed. And finally, the complainant had demanded his money back. The case of complainant was that to repay the amount, alleged check had been issued by the accused. When the check was submitted in the bank, it was dishonored, and finally notice was given and case is filed. In that case, the accused was convicted by trial court but finally acquitted by appellant court. So whenever we are going to fight the case of check bounce, first understand the theory of prosecution and then divide the case in two parts. Number one, the prosecution and its weakness, and number two, the stand of the accused. In that case, the prime attack of the accused was that there is no document on record to show transaction of rupees 35 lakhs. Even there is no document on record by the complainant to show that he was having the said money. Even on that day, the said money was not in his bank account, and even it is not shown in the ITR. So basically, the concerned accused challenged the financial capacity of the complainant. it is permissible. And apart from that, we must understand that if there is any agreement regarding purchase of a land, in that scenario, Section 17 of Registration Act is quite important, which says mandatory registration. But in that case, no such scenario occurs. So, if the prosecution withheld the material fact and there is no legal compliance, in that scenario, the prosecution loses its strength. So, basically, we have to attack at inception on the existence of the prosecution, and then we have to come on our stand. The stand was that the check has been taken forcefully. Regarding that, the concerned accused submitted the intimation given to bank and police, and these documents were not rebutted by the concerned prosecution, means complainant. So basically, if you are going to take a defense, you have to prove the same. The circumstances must be justified, and it must create a suspect in the case of prosecution, and apart from that, corroboration is also required. If you say that the check is misused or it is stolen, it is taken forcefully, there might be a police report, and investigation must be in your favor so that you could have the benefit. So, in simple words, we could say that the accused is not required to prove his defense beyond reasonable doubt, but the probabilizing effect must be on record. In addition to this, two important judgments are to be noted: 2007, Volume 5 SCC, page 264, and number 2, 2006, Volume 6 SCC, page 39. I will take another example to explain you more effectively. For example, your defense is that the check is given towards security. The defense will fail if surrounding circumstances are not on record. For example, there is an agreement or contract. Number 2, as indemnity. The check is given as security, and you are having evidences. In that scenario, you could put up the same and could challenge the stand of prosecution. For example, if the prosecution says the check is given towards a debt, but your stand is that it is not towards any debt, it is towards security, and with the help of documentary evidence or any communication, you are totally able to prove the same. In that scenario, the prosecution will fail, and prosecution has to explain why the facts had been concealed and why the true facts were not placed on record. So I think that I have specified you the manner in which you could contest your case and could proceed accordingly. So in simple word or in concluding words, we could say that whenever we are having a check bounce case against us, always attack on the prosecution and then attack via stand of the accused. If the defense is weak, the defense is general, it is not with specific corroboration, then you could not be succeeded. So simply what we can do, consult a lawyer who is expert of subject. Number 2, do consultation. Number 3, then do review. Number 4, then make defense line, and then attack the prosecution. Because if there is non-compliance, then we could have the benefit. For example, if Mr. A filed a case against Mr. B regarding a check bounce, but facts on record simplifies that the check is given by a company, but company is not made as party, then there is violation of section 141 of NI Act, then Mr. B could have the benefit. So everything depends upon us in which manner we are going to contest. So simply study the entire file, do proper review, make defense line, and then proceed to attack the prosecution. See you in the next lecture. Till then, Jai Hind, Jai Bharat.